Good morning, ladies and gentlemen. We have reached the last session of our virtual academy. And this session is negotiations and mediations. And as you are aware, the Arbitration Academy was a membership drive. I'm pleased to announce that we have over 37 new members. I'm looking forward to next year's membership drive, thinking about interest arbitration. Grievances are generally processed in steps, and it's the drafter's hope that grievances are resolved at the lowest possible stage. Effective negotiation provides this opportunity for early resolution. You may also have provisions in your CBA which require union and management's discussions before change is implemented. Effective negotiation and mediation provides opportunity again for resolution. Have you ever considered why some contractual provisions were intentionally left vague? May I suggest here is another opportunity for effective negotiation and mediation. Today, Joe Trejo and Carolyn Borden, who are members of Colera, Joe himself is one of our board members, will discuss negotiation skills and mediation and grievance arbitration. Joe Trejo is a federal mediator with the Federal Mediation and Conciliation Services in Columbus, Ohio field office. Mr. Trejo has been with the agency since June of 2011. Joe's primary responsibilities includes advocating, collective bargaining, developing, and advocating the practice of conflict resolution through the use of alternative dispute resolution, and establishing a joint process to improve labor management relations. Before joining FMCS, Joe spent 8 years with the Office of Collective Bargaining with the state of Ohio, departing as the manager of labor relations and dispute resolution. At OCB, Joe was responsible for managing the mediation and arbitration programs for grievance resolution, provided consulting, training services to agencies, human resource staff regarding employee relations. He also reviewed and approved on grievance responses issued by the state prior to arbitration. Joe also represented OCB at OCSEA Local 11, AFSCME Ohio Healthcare Employees, District 1199, SEIU Ohio Education Association, and the Ohio State Troopers Association. Joe started his labor relations career as a member of Teamsters Local Union 284 in Columbus, Ohio. He was a union member for close to 20 years, with more than 10 years spent as a steward and 3 years as a secretary treasurer. Joining Joe in this presentation is Carolyn Borden-Collins. Carolyn is the owner and president of Borden White and Associations, Inc., an alternative dispute resolution company. The company provides in arbitrations, mediations, facilitations, and public service sector human resource consulting. Carolyn's diverse professional and life experience has given her a balanced and insightful perspective on a conflict that can arise between employers and employees. Carolyn began her labor relations career in 1986, and I hate to date her, when collective bargaining began in the state of Ohio. While an employee of the state, Carolyn served as an organizer to form the bargaining unit and served on the union's negotiations team for the first labor contract between the state of Ohio, Office of Attorney General, and OCSEA AFSCME Local 11. From 1986 to 1989, Carolyn served as a union steward and executive board member for the newly formed bargaining unit. Starting in the 1990s through 2013, Carolyn served as a management representative at the Ohio Department of Natural Resources, Ohio Department of Developmental Disabilities, and Montgomery County Board of DODD, and the Ohio Department of Job and Family Services. Her experience as a management representative included advocacy, negotiation, grievance management, reorganization, and executive leadership. She served on the negotiation team for the multiple contracts between the state of Ohio and OCSEA, SEIU, 1199, and OEA. As a mediator, Carolyn has extensive training in meeting a broad range of issues, including employees' disputes, civil disputes, special education, and criminal misdemeanors. Carolyn would like to expand this to labor mediations. Now, without further ado, I'm going to turn this over to Joe and Carolyn for their conversation on negotiations and mediations.
Well, good morning, everybody. I hope everybody's doing well today. I just want to do a little bit more on the background. I'm going to share my screen here. Can everybody see that? Can you see it all right? All right. So Maida was introduced, and I'm with Federal Mediation and Conciliation Service, and our mediation is probably a little bit different. My role is a little bit different than Carolyn's role as a mediator, and kind of wanted to get that out there. As a federal mediator, everything we do is no charge. So for us to get work and for us to do a lot more than just mediation, I do a lot of outreaches where I go to lunch with people, I meet people, tell them about our services. We do grievance mediation, contract mediation, relationship development training, all kinds of stuff like that, where we work with managers and companies and the unions together or separately, where I'll go out and do trainings for if you're coming up to collective bargaining. If you want collective bargaining training, I can come in and do that for both sides, one side, whoever wants it. I participate in labor management trainings, facilitate labor management meetings, do workplace mediations for companies. So my job is strictly to go out, have relationships with people. Through those relationships, they call me and say, "Hey, Joe, I need your help." The state's a little different. I know there's, from what I can see, I know some people on here who are with the state, where you have a panel of mediators, which is totally different. That you kind of frown upon a mediator on your panel going to lunch or something with one side or the other, and the other side hearing about it and go, "Hey, what are you doing going to lunch with the management side or the union side?" You favor them, or you make rulings. Where as a federal mediator, I don't make any rulings. I can't. I'm not an arbitrator. Also, I'm strictly a mediator. And our role as a federal mediator, we make no rulings. We can't tell one side or the other, I agree with you, and this is the way it should be. And I can't do anything like that. When I leave, it's the parties come to an agreement. They come to agreement on their own. If they want an opinion, if they don't, I might give an opinion. But I also make it clear this is one man's opinion that's been in this business for a while, and this is kind of how I look at it. But I never say one side is right or one side is wrong. I don't give that ruling as a federal mediator. We're true neutrals. And we'll explain a little bit more about the mediation process and the confidentiality in that later. So Carolyn, if you want to talk about your role as a mediator, how what you do is kind of frowned upon. Of everything that I do to get business is kind of frowned upon, of what you do and being on a panel and things like that.
Sure. But first I want to address Mita saying she didn't want to date me. Well, 1986 isn't truly dating me, because I started working at the state in 1972. So don't feel so bad. So it's been a long journey, and I've appreciated every step of that path. As a mediator now, I am on one panel, but it's for special education. And then other mediations I've done has been within employee and employer settings, in private agency type of thing. So it is important for me to maintain my neutrality. The parties would be very upset if they saw me laughing and joking in the parking lot with either the school district or with the parents, or having lunch or dinner with them, or that kind of thing. That's very frowned upon. It would hurt my credibility as a neutral in the actual mediation process. So I do not do that, but that's not to say that relationships aren't important. They very much are. But in order to guide the process and get people to resolution, they need to feel comfortable. They need to feel that they're in a safe zone. They need to feel that they're being heard. So that's why it's important for me to keep that neutrality.
All right, so from there, as we go through, if you have any questions, please, raise your hand and we'll try to, Carolyn and I will, if Maida can help, we'll kind of look at that and try to answer questions as we go. So, so from here is what we do as mediators is if you come in front of us, is the first thing we're going to do is once we introduce ourselves, just like Maida did, and kind of give our backgrounds and things like that to make the parties feel comfortable. What we do then is we go around like we're going to do today and say, give me your name and position. Here today is, personal quality, helpful in resolving conflict, because this is what we do. When we come in, usually, not always, but usually there's some type of conflict. Or, even if there isn't, they'll have, especially on my end, they'll have me come in a lot of times and just say, hey, Joe, we want you to come in and just sit in our labor management meetings, because when you're there, things go a little bit smoother and everybody plays a little nicer because they don't want to look bad in front of the mediator. And, and sometimes I'll jump in and make some comments or, give my 2 cents every now and then about, calming things down or doing something. And if you've ever participated in a mediation, because that helps us as mediators know who our clients are and who's in the room. And a lot of what we do sometimes, knowing the parties and knowing the experience that's in the room, is we have to do a lot of training sometimes when we're in there. Well, here's what, this is going and this is why it's happening. And, don't be upset, and believe me, when I'm in both rooms, both sides are usually upset. So it's calming the parties down, especially if you've never been through the process of negotiations or mediation. It's calming the parties down because you have your own personal views and you take things so personal, which you should, but half of what we do is just calming the parties down, letting them understand the process and why it's going the way it's going. And, that we'll get through this. You just have to be patient. So I'm going to stop sharing my screen. What I'm going to do is go to each person that everybody's screens are different. So I'm going to go from my screen and just tell me who you are. Like I said, a position that you have, anything that you think is helpful in resolving conflict through your experiences, and if you've ever participated in a mediation. And if you forget something, believe me, I'll help you. So just so everybody knows who's in the room, that's what mediators do. We want to know who's in the room at all times. It helps us out. So Mita, if you want to go, and then we'll just go down, you're just quick of who you are. And I know you sat on a couple panels that you might get some work out of here too. So everybody, I'll just say a name and you just go down. And so Mita, you go first.
My name is Mita Bass. I'm a neutral, and as a neutral, I'm an arbitrator, a fact finder, a mediator, a conciliator. I think that covers it, right? Question. I'm a good listener, so that's what I bring to the table, and that's helpful in resolving mediations. I've only participated in mediations as a mediator, not as a participant.
Which is totally different. I've done both. So I have Bernadette. You're next on my screen.
My name is Bernadette Tiemann. I work for Lyra. I have not been involved in any mediations as either party.
Okay. How you doing, Jenny? I have you next, Jenny. How are you doing? Been a while. Are you muted?
Broke it. But it's cold downstairs.
Yes. How are you?
I'm
It
doing
has been
good.
a while. It has been a while. My name is Jenny Lewis. I work with OCSEA. I am currently the paralegal to the general counsel. I also have been a staff representative, field staff representative. I did that for 12 years. I've been with OCSEA for 22.
So
And mediations, as far as grievances are concerned, that's the kind of mediation I participated in as an advocate.
It's been a lot of them, right, Jenny?
Quite a few.
So what personal quality do you think is helpful in resolving conflict, Jenny, in all your experience?
Understanding both sides.
Great.
You have to understand where the other side is coming from, or at least appreciate it.
Mhm.
Good.
Yeah.
So Emily.
Emily Smith.
Position, Emily?
Oh, I'm the executive director at Lyra.
All right. You ever been through mediation, Jenny or Emily?
I have never been through mediation, although I have watched one bargaining session, which was really fascinating.
Did it make you want to go back and do it again?
Well, it looked like a really, it looked like an incredible amount of work.
Absolutely.
Yeah, it looked like a lot.
And it is. So Amanda. You're on mute. Go ahead, Amanda. You're on mute.
I wonder if something is off with her sound.
Can you hear us, Amanda? We'll come back. Let's see, Dot, how are you today?
I'm doing well. I'm Dot Yeager.
Good.
I'm the Chief Business Officer for the Franklin County Board of Developmental Disabilities. So my ears perked up when you introduced Carolyn. The people have already talked about the qualities that would seem to be essential for resolving conflict, which is listening. So I don't always do as good of a job of that as I ought to. So, and currently going through my first experience with mediation.
It's going great, right?
It is going great.
We won't say who the mediator is, right, Dot? All right, great, nice seeing you. Let me see, who else? We want to make sure nobody gets out of this. So Delphine, how are you?
I'm doing well, Joe. Long time no see.
That's right, yeah.
My name is Delphine Mays. I'm the Labor Relations Officer for the Department of Insurance. And I would have to say, well, I've been on both sides of mediation pretty much, on the union side and now as, the advocate as well, or the on management side. And I would have to say the one thing you should remember is try not to put personal feelings on the table.
Absolutely. And I know you've been through some mediations. I've been there with you every now and
Yes,
then,
you
once in a
have.
while.
Yes, you
Nice
have.
seeing you again.
Nice seeing you too.
Okay, let's see. Mickey?
Morning.
Morning.
And I'm with OCSEA and I'm a field staff rep as well. And I have the grievance procedures I have advocated for the union in mediation as well as arbitrations. And one thing I will say, it's best if you can find a meeting point to try to come together to settle things if at all possible.
Great. How long have you been a staff rep?
Tomorrow's my anniversary of 4 years.
Oh, good. I'm surprised I haven't seen you. What agencies you have?
So I have DNR statewide, I have Commerce statewide, and then I have like 9 other conglomerate chapters.
Oh, okay. Good. Nice to meet you. How about Andrew?
Hello.
How you doing?
I'm doing all right. How are you?
Good.
Andrew Fortledge. I'm with the Fraternal Order of Police, Ohio Labor Council. I'm an attorney there. I'm actually a brand new attorney, so I have not really had a ton of experience with mediation as of this moment.
So you work with Gwen?
I do. Yep.
Was you at how long have you been there? Was you at the retreat?
No, I just started last day of November, so I've only been there a couple months. Yeah.
Well, you just missed me because I spoke at your retreat, and that's why I was like, the face didn't look familiar, so that's why.
Yeah, you wouldn't be able to forget this beard. So
nice meeting you.
Nice to meet you.
All right, Corey.
Hello, everybody. My name's Corey Wilson. I'm the 3rd District Vice President for the Ohio Association of Professional Firefighters. I'm a field service rep for the IFF, the International Association of Firefighters. I've been involved in several mediations, and I'm happy to say that 100% deals every time. So
That's good. All right, let's try Treva.
There we go. Now we're cooking. So I'm Treva Nasal. I am the Chapter 2515 president here at ODNR Central Office. I'm also the ODNR Assembly President that covers statewide and a steward. So I would say that I think discovery is important. So those aha moments, I think in like through communication, verbal communication, because a lot of times I know that sometimes when there's written communication on a grievance or documents, it's assumed that everybody knows, but there's always, you know, the Paul Harvey rest of the story. And sometimes I think through the verbal communication interacting, you know, you find out things and discover about what's really going on. So I think that's a piece to something that I find interesting. But yes, I have been a participant in mediation.
Great. So let's go back to Amanda. She said she's ready now.
Yeah, I apologize for that.
That's all right.
My name is Amanda Schulte. I work for SEIU 1199. We created a department, we're calling it our Member Resource Center, that just focuses on grievances. So I'm the deputy director of that department. A special quality that I possess, I think, is that I can be just relentlessly positive, probably sometimes to a fault. But I think it helps me get through a lot of things in our line of work. And yeah, I have done mediations now the entire time I've been here, which has been 11 years.
Oh, well, that's good. Surprised I haven't met you earlier. So you work with Josh?
Yeah.
Have we met?
Yeah, we've actually met before a couple different times.
Okay.
But you know, all between here and Cincinnati, I think.
Oh, okay. Great. Nice seeing you again. Nicole.
Hi, Joe.
How are you doing, Nicole? Nice to see you again.
You too. So I work for OEA. I'm a labor relations consultant. I am an attorney, and I represent locals in the central OEA area, Pickerington, Groveport, Madison, Reynoldsburg are my largest locals. And I also just got out of mediation with Joe and my own personal staff union issue. So
We're still working on that.
yeah, we're excited for arbitration right now. So
All right.
Mediation on my own behalf and mediation for my members.
Nice seeing you again, Nicole.
You too.
Bree, did we do Bree?
I am management side representative for Columbus City Schools. I, in previous roles, have experience as a management representative in grievance mediations.
Good.
I think an important quality in grievance mediations is for the parties to know what they can give on and what their bottom line is when they are going into the mediations.
Bree, how long have you been there?
I've been here since September.
So I think you just started when I was there, right?
Yep, I was just starting at the end of the OPSI contract there.
Right. Yeah, I was going to say, I thought you had just started, but it's different seeing everybody without their mask. You know, I knew the name, and when you said, and I was like, I think but she was new in that. Yeah, it's nice seeing you again, Bree.
You too.
So Ellen.
We'll figure this out one day. Good morning. How are you?
Good morning.
My name is Ellen French. I'm a senior HR administrator for Franklin County Board of Commissioners HR. I've served as the neutral party in step 3 grievances is my main experience. And I'd say the most important thing is to be able to connect with both sides, at least in this position, and making sure each side has somewhat understanding where the other party is coming from, to build bridges and not walls.
Good. Yeah. It's nice meeting you.
Nice to meet you.
So I'm really bad. So Michael, if I call you, you've already done it, then I apologize. Just say I've already done it. Michael? Nope. Aaron?
Well, while we're waiting on people to answer the roll call, I just want to say the comments that you're making about how you apply your negotiation mediation skills in the work that you're currently doing, or what your experiences are. You're hitting on a lot of the key points that we'll talk about later in the presentation about the qualities of a mediator and how those are applied within the mediation. So good job.
Is Dennis on?
Yeah, I'm here. I just don't have video today.
That's all right. How you doing, Dennis?
Not too bad. How you doing, Joe?
Good.
I missed the intro, so I'm not sure what all you're asking people to say.
Just name, position, you've ever participated in mediation, and what do you think is a quality to help resolve conflict?
Sure. Dennis Dugan, I work with the Ohio Nurses Association, specifically with the Ohio State University Wexner Medical Center nurses. We're about to go into negotiation, so maybe this is real timely. I've done mediation mostly in the context of negotiations, not so much in grievances. And I think I like what I already heard, which is knowing your bottom line is really important. I also think that there's a certain level of commitment that both parties need to have to resolve the issue. Otherwise, mediation is not generally useful in my experience if the parties aren't serious.
Good. Thanks, Dennis. So what we're going to do now is, so you know how it kind of goes in mediation. Those that didn't get to introduce themselves, anybody that wants to can, and anybody that doesn't, we're going to go ahead and move on so we can get through this and get you out. Not that we don't love to hear from everybody, but I think you can see, you know, from what Carolyn and I do in our work as we, you know, have relationships with a lot of these people we've been in front of, you know, been in front of us, been with us working on stuff. So it is a small kind of world when you're in this business. And so let me go ahead and start sharing the screen again, and then we'll go ahead and start going through the process.
All right, I'll be here.
Is everybody back
I don't
up?
need to.
Can everybody see it? So the first thing we're going to talk about is kind of just real quick on the negotiation process steps. And, you know, what Carolyn and I do, this training we're doing just on this would be, you know, an all-day training. So you guys are going to get the condensed version of the trainings that we do. And we're going to kind of go through it, ask questions. At the end, you can ask questions. You have 2 seasoned mediators here that is willing to, you know, answer your questions. So during the negotiation process, you know, before you get to mediation, if you're doing contract negotiations, we can talk grievance mediations. It kind of works about the same way. But in the negotiation process, make sure that when you start negotiations, before you do, that you go over ground rules. And some of the things in the ground rules you'll need is scheduling. How often are you going to have the meetings? What days are you going to have the meetings? What times are you going to have the meetings? You're going to have it during work time, after work time. You're going to have release time for the members and the management team to be released to negotiate during the day if needed. You got to talk about confidentiality, and that is, what do you do about negotiations? Do you let each party report out on their own and that, or do you have kind of a blackout where both parties agree that nothing's going to leave the meeting, and unless both parties agree this is what we're going to say? Another thing would be who's going to take the minutes of the meeting, and, you know, kind of agree on that type of thing. You know, your first meetings, when you first meet, after you get the ground rules done and that, your first meeting, you're going to do opening statements on each side.
You like him so he can charge his thing?
If everybody can mute themselves.
He's not playing.
Okay, thanks. First meeting, exchange of issues.
A little bit.
Parties opening statements, usually both sides will give an opening statement. You'll exchange a list of proposals, explain, you know, kind of why you want, what the proposals are. Each side will get a clarification to make sure that they understand what the proposal is. A lot of times when Carolyn and I get involved, that's a lot of the issues is because when they go through the proposals, they don't ask, what do you mean by this? And sometimes they're kind of arguing different things because the parties think they're talking about a different issue. And so make sure you're on the same page and go over the issues and both sides know what they are. In the early meetings, you usually start out with non-economic items. You try to get through the non-economic items. You try to start with the easier items and get to the harder items. You know, a lot of times the movement is based on the value of the issue. So, you know, the least valuable you'll start, and like I said, and go toward more of what you want. The movement is based on perceived movement by the other side. So, you know, if they make a big move and give something up, then they expect you to do the same thing. If, you know, you're just giving up some, what we call throwaway issues that are on the table, just to be on the table, the other side's going to say, well, you run, take those off anyways. Those don't mean anything. So, you know, that's usually how it goes by movement. once you start getting involved in the negotiations, you need compromise on both sides. I always say when I go to mediation and I see all these issues on the table, the parties need to compromise. And if I leave and both sides, are happy they got a deal, but they're kind of sad they didn't get everything they want, then as a mediator, I did my job, because one side didn't get everything they wanted. The other side didn't get everything they wanted. So there was some compromise. You want to clear out as many items as you can before you get to economics. Once you start getting farther down the road and there's less issues on the table, then a lot of parties will go what they call packaging. They just do a complete comprehensive package. Here's everything, that we want, and here it is. And the other side will counter with the full package and say, well, here's what we're going to give you. And you just start horse trading. You give this up, we'll give this up, and, things like that. So when you close out the session in negotiations, some movement is, timing, and both parties will hold something back until the very end and, say, okay, well, to get this settled, I'll give up on this, or I'll do this. And so timing is a lot of part of the negotiation process. You don't want to get to the bottom line until you know that this is it. And, if you say this is it, then, that really should be it. The other side's not going to be happy or have faith in a good negotiations if, you get and say, this is my bottom line, and you go, oh, okay, not that. Okay, well, this is my bottom line. And okay, now this is my bottom line. So, if it's your bottom line, make sure that it's your bottom line. I don't know how many times I have a conversation that says, Joe, every negotiations we have, we give them the last best final, and they always turn it down. And I go, well, what happens after that? Well, we come back to the table and then we give them another package. Okay, what happens after that? Well, a lot of times then they'll go ahead and take it because they just turn the first package down every time. How do we get around that? And I tell them, well, if you say this is it, then that's got to be it. And if they turn the first one down all the time, then make sure that that's not your bottom line then, so either it is, or when you say it's my bottom line, they're going to turn it down, you have a little bit more to give. So only you can stop that process. And then any non-economics that you couldn't get settled, a lot of times you settle it in the economics. You can throw it in there and say, well, this has been out there. We didn't settle this. So to settle it, we need this too. And then, do we need mediation? So once you go through the process, do you need mediation? And, that's kind of where we come in. So, there's a difference between mediation and arbitration. And like I said earlier, I'm a mediator. I'm not a mediator and arbitrator. I'm just a mediator. So, through mediation is the relationship between the parties. And when you go to mediation, you have to understand, if you're going to mediation, what you're saying is we have room to compromise. When we go to mediation, I'm going to have an open mind. I'm going to listen to the other side. The mediator is going to help and throw ideas out and help with the process. If needed, help calm the parties down. A lot of times it's help one side or the other who might have a problem with somebody on their team to say, hey, Joe, we need help. We could get this done, but we have this one person on our side who just, won't let it go. They're just they're so personal about it and they won't let it go. So, half of what we do is to look at and say, what is it that you have to have? And, we make that person talk and say, what is it you need to get this done? And have those conversations. but it gives the parties more control. When you're in mediation, the parties have control to get the deal done. Once you go to arbitration, you don't have any control. It's going to be whatever the arbitrator decides. And depending on the history of the arbitrators that you might know, if you have a panel of arbitrators that you use, and that, you know what their rulings usually are, which way they kind of lean. A lot of times, hey, they do 50-50 and they won that one last time. We'll probably win this one, or they'll split it, all kinds of things like that. So mediation, the parties reach their own decisions. You have an investment in the outcome. So you control your destiny in mediation. Also in mediations, when you're working with a mediator, which it's grievance mediation, regular mediation, all mediations with the mediator are private, confidential. There's no records. There's no tape recording. The mediators are protected under federal and state laws that we can't be subpoenaed to testify in cases when one side, wants to sue the other side about negotiations and say, hey, we went to mediation. Let's subpoena the mediator, talk about what happens in mediation, which the subpoenas will get squashed because we are true neutrals and we can't do our job if you can't be open and honest with us in private caucuses and communications. The first thing we say when we're in mediation is be open and honest with us in private caucus so I know what you want and what you need. When we say there's no records, you can take notes, but if you don't get a settlement in mediation, if you go to fact-finding, conciliation, or if you just go outside of that, whatever your next step is, you can't say what happened in mediation because they're private and confidential. You can't use that in fact-finding or conciliation or the next step and say, well, in mediation, this is what they offered. When you're in mediation, it's like when I leave, it's like the meeting never ever happened. My notes are destroyed. I've had a lot of times where somebody will call and go, hey, Joe, you remember when we were in mediation? Do you remember the party saying this? And I go, no, I have no recollection of what happened. You know how many mediations I've been. I don't have my notes, and I'm sorry I can't help you. In mediation, the process is less formal. You allow for flexibility and creative solutions. That's what we're there for. We try to get you to think outside of the box. With our skills and knowledge of dealing with other negotiations who might be in the same type of field, and we know what they do there or what's worked there. We can bring that into your negotiation and go, hey, do you ever think about this? Have you ever thought about that? And our whole job is to keep the communications open and going. That's all we do. Let's keep the information flowing and going. So Carolyn.
Yeah, Joe. So a little bit on what the role of the mediator is. As a mediator, I am an advocate of the process itself, the mediation process. And there's several different models that are used. I use one that's called the 7 stages. And I'll just go over those real briefly. One is introduction. The next is telling the story or problem determination. Summarizing is a third step. Step 4 is issue and interest identification. Stage 5 is generation and evaluation of alternatives. Stage 6 or step 6 is agreement. And step 7 is closure. So while those are very formal, if you're a good mediator, you're moving through you're transitioning through those stages very smoothly. It's important to hit each stage. The introduction, you're going to know who the parties are, particularly if the mediators never met you. Now, I realize with people in the state or possibly the county, you have a panel of mediators, so you know that mediator. and the mediator is going to be familiar with you as well. But if you're in a true mediation where it's all neutral, you don't know the parties, then it helps to have the introduction. It also helps for the telling of the story. Whoever's telling the story and who's not telling the story, you're both very active in that. I allow the parties to share freely, to vent if necessary within reason, because while they're doing that, I'm listening and catching possible points of agreement. And if you're listening to the other party, you should be doing the same. Now, if your style is positional bargaining is all based on what I want, what I need, and this has happened, and there's like no movement. You are positioned. As a mediator, it's our role to move you to a more principled type of bargaining or negotiation, where you start to separate the people from the problem or the issue, and you start focusing on interest. And once again, that gets the mediator to start identifying, here's an acronym. Having worked for the state for many, many years, you guys know there's an acronym for everything, particularly at DODD. So here's an acronym for you. It's called ZOPA, Z-O-P-A, and that is the zones of possible agreement. Those zones you should be listening for as an advocate while the other party is telling their story. And I should be listening for that all the time, because the way you're going to reach resolution is when you can start chopping away at those little points within that zone of agreement. And then when you get to that bigger meat of the issue, hopefully you've calmed down enough because you say, well, I got that, or we reached agreement on this, and then you can work your way to that bigger issue. As a mediator, I need to set a balance in the room. Many times there's an imbalance of power. You might have a grievant who is an employee in any level of the organization, and you might have the director or the supervisor of the unit or someone in a position of power in the workplace. So as a mediator, it's my role to set a balance of power. So that all happens as you're setting the tone in the introduction and telling the story. People have to feel comfortable. They have to feel their own equal table, right across the table from each other, before they can get to identifying the interest and the issue itself. You might come in thinking you've got one issue, but as the parties are sharing, there may be other sub-issues, so to speak, that come up that need to be resolved before you can get that bigger issue resolved. Brainstorming or generating alternatives, that's critical. Because if you're truly listening and you're trying to identify those possible points of compromise, you can start generating alternatives. And the freedom in that is saying, look, I'm throwing this out on the table. I'm not saying I'm agreeing to it, but I'm throwing it out there. That gets all that energy and juices going. You pose positive and negatives during that time. Then you start working towards your agreement. So do you have any questions about what the mediator should be thinking or isn't thinking, or anything you ever really wanted to know about the mediator when you're in that setting? No questions? Okay, well, I'm going to go into the next slide.
Hold on a minute. I'm getting there.
That's okay. Okay. So mediation starts before you get to the table. I spent the majority of my career as an advocate. So you really need to know your contract. You need to know your issue. And particularly if you're going to mediation before you go to arbitration, as an advocate, all of you who are advocates out there know that, and when you're preparing that case, you go through stages where you have got the best case anybody ever had. They should make a television show about you because you're going to go in there and you're going to win that case. I've been there many times. And you also hit points when you're preparing, like, oh my God, this is going to happen, or my management rep did this, and what am I going to do? I'm going to lose this case. So you need to hold on both of those feelings. But in order to frame your issue, in order to really know it and understand it before you go to the table. I talked about ZOPA, the zones of possible resolution or agreement. You need to know your BATNA and your WATNA. And I asked Joe to put this in here just because I love saying BATNA and WATNA. Sounds like, you want to impress somebody, you can say, well, the BATNA on this case is. The BATNA is your best alternative to a negotiated agreement. So remember the feeling that I said you have as you're preparing your case as an advocate, that you just know you're going to win? Then that might be your BATNA. But bear in mind, you have a WATNA on the other side, the worst alternative to a negotiated agreement. So if you think you have a case and you really think you're going to win, you have to realize that you are putting that control in the hands of a third party completely, where an arbitrator is going to say, this is what really is, this is what it is. And you might fall on your sword. And after you've fallen on your sword, you might think, man, we should have mediated that case. I don't want you to be at that point. I want you to think all through those things before you come in to the table to mediate. Does that make sense? Any questions about that? Now, your WATNA is your worst alternative to a negotiated agreement. This is where you want to think about, are you going to be setting the precedent, even though the agreement you reach is going to say it's non-precedent setting? But what message are you really sending out there with whatever settlement that you come to? Is it reasonable? Is it practical? Is it manageable? Those are all things that you need to consider when you're framing your issue and when you're going to go in front of the mediator to present your role, your position, or your interest. Relationship building. I say it's all about relationships and mediation. Relationship starts with you and your client, whether it's the grievant, or it's the manager in the office, or it's the director of the agency, or it's your executive director at your union. You have, as an advocate, you have someone that you're reporting to. So you have to build a type of relationship where they trust you, because you want to be able to come in with the authority to settle at the table. So you have to be open and honest with them and let them know the benefits of going forward with mediation, the reality of what your case might be at arbitration. And the more honest you are, the more upfront with you, even as uncomfortable as it is, because you're probably going to hear, you don't go back to the workplace. You're not on the front lines. If I lose this case as the grievant and I have to go back into that workplace, you're not going to be there with me. And you're going to hear the same thing from your agency leads, that if you settle this, you're going to make it hard for me in my day-to-day work practices. So being honest about the pros and cons of that, your client's going to trust you to go forward and speak for them. Relationship building also with the other party. Now, we talked about my role as a neutral opposed to Joe's role, where I'm not super friendly with the parties. But as an advocate, you have to know and respect the other person sitting across from you. You need to know and respect your union leadership. They need to know and respect you as a manager, but as a management advocate. But you have to earn that trust again. You have to know your truth, speak your truth, and be authentic, because that's the only way you're really going to reach an agreement that's going to be effective. I know when I was an advocate, sit down at the table and we would be going at it, you know, the union and me, but we get up, we walk in the hall, we say, hey, how's your kids? Want to go to lunch? You know, and people didn't understand that, but that was because we respected the other person and we weren't linking the person to the issue. You should know your mediator. Does the mediator want a lot of detail? Do they want a lot of background? Are they really, or do they want a position statement? Are they going to do shuttle mediation back and forth and put you in caucuses? It helps for you to know your mediator and their style and what to expect. And then you will gain the respect of the mediator if they know what to expect from you. The other part of this whole relationship bit is you. After each mediation, ask yourself what I did right, what I could have done better. Did I really come prepared? Did I have to back off of what I thought I was going to get? And what can I do differently next time? It's so you are constantly learning and growing from each case that you participate in. Any questions or comments or examples that you could give of that? Joe, do you have any examples of cases where you knew your BATNA and your WATNA, but you went ahead and mediated and not settled? Or
Well, yeah, I mean, you know, what I got to say is, you know, about knowing the mediator and what kind, there's all types of mediators, different, the way they do things and that. And mediators, when we get involved, what you got to know is we have no idea when we walk in the room what the parties' issues are. And, you know, some people think when we come in, we already know what's going on, and we don't. And we want it that way for a reason, because we don't want any preconceived notions of when I go in there, what the case is all, you know, I've talked to this group and they tell me this, we don't have conversations. So that's why, you know, at the beginning, I say, be patient, because I want to ask a lot of questions, because I want to know exactly what's going on. I want you to tell me what the issue is. And I try to be thorough about it. But once you start your case, some mediators will say, I'm not asking any questions. It's up to you to present a case to me. And, you know, that's your job. It isn't for me to say, hey, well, what do you mean by that? Or, you know, and other mediators you'll say, what are they doing asking questions for? They shouldn't be asking questions. So every mediator is different. When we say know your mediator, then, you know your mediator, what they want when they come in. Some will say, take me to the contract language. I want to see what it is. And some will just say, just explain it to me, you know. So there's all different ways, but, you know, as a mediator, you know, you fill the mediator out just like the mediator is filling you out of what is it that they want to hear? What is it that they want to know? And that's all I really got to say about this one is, you know, all mediators are different. You just got to be patient with us when we come in, because we don't know what the issue is when we come in. We don't. All we do is, Joe, give us some dates and times you're available. I give them, okay, let's schedule this. And it's all right. See you there. I mean, it's usually just quick emails and picking dates and times and all right, we'll see you then. And that's it.
well, I would say that some of my cases I do a little differently. The ones that I do for special education, I will talk to each party separately prior to the mediation, but I do let the other party know. When I'm scheduling, I'll say, look, I'm going to want to do a really brief background call. It's just for me to get some background information. And then, but I have to be very careful when I do that, because the parties will start to advocate and try to get me to agree. And I have to remind them, I am just gathering information at this point to save us time when we do get to the table. I'm not your advocate. I'm not forming an opinion. But it helps when you have a lot of really, lot of technical issues or concepts that you might not be acronyms that they might not be familiar with going into the table. So I do talk to people briefly just to gather that background. But if you're dealing with, you have a panel, those mediators and arbitrators know you as advocates, and so there may be a less need for background gathering. I see Bruce Thomas has a question.
Yes, good afternoon.
Bruce,
Bruce Thompson.
how you doing?
Good, how you doing, Joe?
Good.
Good. I'm sorry, I kind of got into the meeting a little later. I was in another meeting. So if this was asked and answered earlier, please forgive me.
Oh, no problem.
When it comes to mediation and being an advocate for your for a member, and with this life of COVID, and we're on Zoom and Teams, if the member happens to have someone else in the room with themselves, and I'm the advocate in another room, do you separate that, or was that on the job of the advocate of like myself as a staff rep? Should I don't want to embarrass my member or something like that. Would I say that out loud? You know.
That's a really good question, Bruce, because we do live in a very, very different world right now. But what I found with virtual, you can create breakout rooms. And as a mediator, I will, it's perfectly acceptable for someone to say, I need a few moments with my client, or can I like to speak with you privately? And then we'll break out into caucuses. And I always am mindful of the time I spend in that. I will periodically check back with the other party and say, we'll be back shortly. I will also take time and then meet separately with the other party so that they won't think I'm showing favoritism there. But for you as an advocate, that's perfectly acceptable, because you need, it's going to be kind of hard for you to control otherwise. And then as a mediator, if I see things are kind of hard for either party to control their clients, I will remind people of ground rules or set new ground rules that say, I need to keep track of everything that's saying. So I'm asking everyone to speak one at a time, wait till I call on you, try to gain some control that way. And also remind people that it's mediation's voluntary and it's cooperative, and we will treat each other with respect. So those are that's more than the answer you wanted, I'm sure, but those are ways to kind of manage that virtual world.
Bruce, are you talking about, because we're doing virtual and you have a grievance that you're representing and they're at their house, you're there, but they have their spouse in the room with them, or they have other people in the room with them, and
yes,
you as the advocate don't want to say, hey, they shouldn't be in here, and would the mediator control that? And the answer would be, we try and do the best we can unless we know and can see them, and that's part of the issue we have. But if we were there and we would say, when you go to mediation, this is private and confidential, only the people that should be in the room should be in the room. And we would, if we knew about it, we would probably, or at least I would say, is there anybody else in the room with you? If there are, they need to leave, because this is private mediation and they need to leave the room. Is that what you're asking?
Yes, Joe, that was it.
Yeah, I thought so. Yeah, so we would, if you brought it to our attention by, a lot of times I say at the beginning, I try to have, like Carolyn was saying, we have to make rooms and put people in rooms, but, I try to say, give me your cell phone number, I'll text you, because I don't like just to pop in the room, and I always say, I don't want to jump in there while you're talking about me and I hear something. But usually, I would say, text me and let me know if you have if you know that somebody's, and I would, as a mediator, going, hey, I just want to make sure, this is private mediation, only the parties that should be are here. And if there's somebody, they need to leave the room. But it doesn't mean they'll leave the room or we'll see them leave the room. But we would do the best we can to say, yeah, they would need to leave the room.
Yeah.
Oh, I'm sorry. Go ahead, Bruce.
Oh, no, because I had a situation like that prior, husband and wife. And it was information given to me that he wasn't a very nice husband. So, and the issue was with her. And so to, say, oh, well, hey, your husband's got to leave, a better explanation maybe from the mediator is needed so that you don't have that rub.
Yeah, that would be part of what we would do, because, a lot of what we do is protect the parties also. And, in that situation, you would just have to let us know. And like you said, we control the mediation, and we would say, they got to go, or we'll stop the mediation and reconvene at another time. But this is private and confidential. And especially with FMCS, when we do grievance mediation, we have you sign a mediation form that pretty much spells out everything. No, you can't record the meeting. You can't, only those that are in the meetings involved. And so, the parties sign it, and then, we have that authority to say you need to leave the room, but how do we really know they leave the room is the big issue, They go, oh yeah, they left. And it's not, we could say, turn your camera around and they duck, or, so it is hard, but yeah, we do control the mediation, and we would control that if needed.
Yeah, and that's what I was going to say. If you have an agreement in the beginning of who's going to participate, and you sign on that, and the people signing on that participation agreement are going to agree to confidentiality and no note taking and that type of thing. And if you have that, that's something that the mediator can remind folks of if you've got someone that's really disruptive. If I have people that I think might be disruptive, I'll ask to caucus just with the advocates of each party, and we'll have a conversation about what might be going on, and then I can intervene there. Or if you as an advocate, Bruce, would decide it's something that I needed to know, you could also ask for a caucus with just the advocates and me, so that I would know what's going on, and I could help handle that. So I hope that answers your question.
Okay, thank you. Thank you to you both.
All right, thanks, Bruce. So that kind of gets us to where we were just at about confidentiality, and, what does it mean to you, and what does it mean to the parties, and, why is it important? When does it apply? What exceptions might there be? I make it clear when I start mediation about confidentiality and how important it is. And it's part of my opening statement to the parties. And, that I can't do my job if you're not open and honest, and, you expect confidentiality from me, and that's what you're going to get. But I might say, when we're having a private caucus, is, hey, do you mind if I tell the other party this? And I think it's something the other party might need to know. And and they say, yeah, go ahead. Then, that's the only time I would do it. But, what you tell me is confidential. I'm not going to divulge anything. I can't divulge, because I lose my neutrality and say, well, we're never going to have Joe do this again because he went in there and told him what we were talking about, and vice versa. So confidentiality is important to mediators, and same on the other side. I told you earlier, when they call me, I go, I don't know what you're talking about. I don't remember anything. And, I've even had people file ULPs against each other, and the Department of Labor calls me and, hey, I want to ask you about it. All I can tell you is I met on this day, and that's it. And they go, okay, thanks, because they understand that what we do is confidential, and that's it. So I don't want to beat this anymore. And I think Bruce brought up a good point about, confidentiality is even of who's in the room. And that is important. And that's why, like I did today, is going through, and part of what we do is I want to know who's in the room, especially when we're doing it virtually. I want to know who's all in the room. So That's all I'm gonna say. I'm not gonna beat this because I know we got some time. We want to get through some other stuff.
I
And
will
think
add, I will add one thing on, that there can be exceptions to confidentiality, and that is if something's getting reported and there's a duty to report it. I'm thinking like in terms of for developmental disability, if during the course of the mediation, somebody admits to abusing a resident, then there would be a duty to report that. So I think that the parties have to understand that, or if it's disclosed that the manager has done something inappropriate to the grievant and it just came to light at the table, then there would have to be measures followed up on that. It wouldn't be me as the mediator doing it, but it would be the parties at the table that might have to break that confidentiality just on that piece.
All right, so.
It can happen. So we talked a lot about this already. Setting the tone right from the beginning. If you don't know the parties, if they're completely new to you, or if you're familiar to them, then a lot of this will be done already for you because you have ongoing relationships to them. It's important to establish right up front what the protocol would be. If you think it's going to be a long day, you might want to talk about housekeeping things, such as when you're going to break, those types of issues. You might talk about that there'll be a time when you'll caucus and what that means and what it doesn't mean, letting the parties know that right up front. The mediator should define what he or she's role is, and also disclose if you think there could possibly be any type of conflict of interest. For example, I would disclose I worked for the state in these agencies if that's a problem. I also work for the union in this role of a steward, not as an employee. So I would state those possible issues of conflict in case the parties would have an issue with it. If they didn't, then we would move on, hopefully. The assurance of confidentiality with those caveats of where there might be an exception. What the representatives are at the table, primarily, are they going to be able to settle? Are they there just to share their story? Is there going to be a joint approach? Like I said, if we're going to use joint or separate sessions, reminding them that it's voluntary, it's respectful, note-taking, however they would normally take notes, make sure that no one's recording. I know when I first started way back in the 1900s, there wasn't cell phones or things that you could easily record stuff with, but we would still say, if you have a tape recorder, or if you're recording, shut it off, put it in the middle of the table because we're not recording. So you would want to take charge of those kind of things because that feeds the trust that you need in the room. And if there's an agreement to mediate, you should take care of that at the beginning. But it's that opening statement where the mediator establishes credibility and trust and sets the tone for that mediation. Joe? Oh, I think the next slide is me again.
Yep.
Gosh darn it. We've talked a lot about all these things already. I would say you need to know what your negotiation style is. If you're going to be positional, and within positional, you can be very hard, or you can be soft with it. You can be still agreeable, but still holding on to your position, meaning I'm friendly with the other side. I really want to settle, but this is what I need. And you're still not moving off of your position. Or you can come in and be very hard with your facts and just say, this is it. I don't want to talk about it. This isn't going to move forward. I must have these things. It's my role as a mediator to ask why. You're saying the what, but what is the why? And the why will get us to those mutual points of possible agreement. And that you've got to know your timing too. Know what your bottom line is, and don't put yourself in a position where you're negotiating yourself with yourself, where you've set that your ultimate boundary is so high, and then you realize, oh, I probably will settle for less. That will hurt your credibility as a negotiator. You got thoughts on that, Joe?
Yeah, I mean, present your case. You got to listen to both sides. You got to listen to the other side. You have to have an open mind when you go to mediation, and you're presenting your case. The timing is impeccable to when you do this long enough to know. And also, you got to remember as an advocate that you're there for representing somebody. You're not there for yourself. And that's the biggest thing. Sometimes we see advocates are holding up the case because of what they want. And a lot of times the side will say, is this what the grievant wants, or is this what the union wants? And you got to look, and I've had cases, and I know somebody telling me a story and says, there's a grievance and the guy loses his job, and the union thinks, hey, he was terminated unfairly, which he probably was, and the management, probably does that, but they wanted to screw with the guy a little bit. So, kind of like the state, they had quarterly meetings. So he goes to the quarterly meeting, they cancel his mediation. So the union gets mad. So you go to the next quarterly meeting, they cancel it again. Everybody's mad. They go to the next quarterly meeting, and this one, it's a arbitrator's there, and he decides either bang, you get it or you don't. And so the union's position was, hey, you screwed this guy over for 9 months. He needs all of his back pay for 9 months, plus his job, plus this. And management said, no, we'll give him his job back, but we're not giving him any back pay or anything. And the members like, yeah, I'll take that. I just want my job back. And the advocate's like, no, you deserve more than that. And so they said, no, we want a ruling. And the arbitrator says, you're fired. So now he's got to go out as advocate and say, you're fired. And the guy said, well, what happened? I'd have taken my job back, with no back pay. What'd you do? And it's like, well, I told him. So sometimes advocates got to realize that sometimes you make a deal and it's the best of what the member wants and not what the union wants. And that's a big thing that we see a lot, is fighting for something that might hurt the member, of settling his case. Go to the next one. Let's see. So writing the agreements, when you're in mediation, grievance mediations, a mediator doesn't write anything. I, as a mediator, don't write anything. The agreement isn't between me and the parties. It's between the two parties. So the agreement is made up by the parties. The parties agree on what the ultimate outcome is. The mediator doesn't. I try to help you get there. I try to bring ideas to the table, but ultimately the parties decide on what the agreement is. And that the parties reach this, through mediation. It's voluntary. Make sure when you write the agreement, the settlement, it's clear and simple language, plain English, where everybody knows exactly what the settlement is. If you need to identify people by their full names, if there's a settlement that's for multiple people, but make sure it says, this agreement is reached between Joe Trejo and whoever, and this is the language, and the parties know the language, like Carolyn said, better than we know the language. You have your acronyms, you put in the language, you go over it. I might sit there and wait till it's done in case, they say, oh, well, I'm not agreeing to it now or something, but the parties write it up, they agree to it, they sign off on it, and it's binding. And, the parties have to live by that agreement that they wrote. The settlement is a settlement, and the parties have to live by it.
And I also have the parties write their agreement. I think that, and I'm sure Joe does this too, and he's just being very modest. You get to a point as a mediator that where the parties should end up. And so through your questions and reframing of issues, you can get them to that point. And if you're a good mediator, they believe it's their idea and that they came up with it on their own. And that's exactly what you want. And I might suggest language, but not too often, but I do suggest things like dates and times and when things will be completed, if those are things that need to be included in the agreement. So I will do that. And in a virtual world, it can be typed. The agreement can be on the screen and it can be done in real time with draft and edits and reach your final. So that's a bonus too. Okay. So Joe touched on these issues. Because that's just how good he is. He's already got this done. Yeah, it's important to, you know, I always tell my parties, good jobs, you worked well. I always let them know that they worked hard and they earned that agreement, and you should acknowledge the achievements that they made for doing it, because it's not easy. You should encourage them to continue talking to one another. I say it's my job to work myself out of a job, to do it so well that the parties can sit down and work through before they have to get to that phase. You know, you thank them for their good job, their hard work. And like Joe said, we put on our trench coat and then we slip out into the darkness and it's like we were never there.
That's right. Yeah. Yeah. Sometimes it's interesting when we go to mediation, depending on what it is. And especially if it's collective bargaining mediation and both sides are contentious, and sometimes we'll get there and we might have a little party out front that we get to walk through to get into the mediation, you know, and sometimes when we're done, we go out the back door so we don't have to see those parties again, or the media or anything like that. So we're never in the media. You might hear acknowledgement that the parties came to an agreement with the mediator, but we don't give interviews. We don't, talk about anything. Like we say, to us, it's still private and confidential, and we don't make any statements.
I will say though, oftentimes in the state or in public sector, the parties may go to mediation it's more of an advisory role. Like, how would you rule if you were the arbitrator on that? So it's slightly different variation to the kind of pure process that we're talking today. But that basically the same types of techniques will work. You're going to need a little bit more explanation on the party's position with regards to contract language. And then as a mediator, you would need to know that contract and know the parties before you could say, well, if I were arbitrating this, this is how I'd rule.
Right. So, a little philosophy about mediation is you can't always get what you want, but if you try, sometimes you might find you get what you need. So, when we get involved, there's a lot of wants on the table, a lot of wants on the table. And what we get through is get through the wants and what are the needs that the parties are looking for. And that's where we try to get to a settlement by trying to get the needs of the parties met, not always the wants. Anything else, Carolyn?
No, I think we hit all our points we were going to talk about. Are there any questions from the group?
So while Carolyn's taking questions, or anybody has questions, I'm going to try to find a little video that Carolyn and I enjoy, that we want to share kind of what mediation is, that we look.
Okay. Lori, I see you have your hand up.
Yes, my name is Lori Roderman. I'm the president of the union at the Dayton Metro Library. We are an independent union. In that, let me think now, 15 years of our existence, we have had to go to mediation 2 different times for contract negotiations. One of those ended up going to fact finding, and the administration rejected the fact finder's report and imposed. And we've also gone to mediation a couple of times over grievances, and one of those went to arbitration. My main question is, when we go into negotiations, our concept is that both parties should bring their opening proposals to the table on the first day. But the way the employer has handled it every time is they don't have anything that first day. They want to see our proposals first. And then they'll come back at the next meeting with what their proposals are. And I just wondered if that is kind of a standard practice, or if we are correct in thinking that they should have a proposal to offer at the beginning.
Well, go ahead, Jody, you want to answer that?
Sure. I mean, and that's part of what we talk about is what is important with ground rules. You need to have a meeting before that and put on the ground rules that both parties will exchange proposals at the first meeting. So that's what we say, you know, you can't just schedule a meeting and your first meeting, and then you try to decide through all this what's going to happen. So always have a ground rules meeting before negotiations start and say, we need to sit down, dates, times, how many people is going to be released? Are they going to get paid for the release? Who's going to pay for it? Lunches, what's going, you know, if you're going to do it all day, how long are you going to take for lunch? A lot of times they'll say, we'll buy today, you buy tomorrow, and we'll take turns. All types of stuff like that is discussed in ground rules. And if anybody ever needs a copy of some ground rules or whatever, let us know and we can send you a copy of some ground rules so you can look at it that people use before negotiations. But that is what is important about negotiations to me is ground rules, and make sure you put it into ground rules and have that meeting that this is how we're going to do negotiations.
Mm-hmm. So you'll know right up front. I agree.
Yep.
Good question, Lori. How big is your union?
We have about 250 members.
That's nice. That's a good size.
Yeah.
Another unrelated question, and it popped into my head and then popped back out again. I'll let you know if I think of it later.
Sure.
All right, so I'm going to put this, let me know if you can, let me share my screen again. Let me know if you guys can see this, and Carolyn and I kind of like this, so. Hopefully everything works with the sound and everything, but can everybody see it? Carolyn, can you see it?
Mm-hmm.
Okay.
You need sound.
Joe, I think you might have not clicked the share sound button when you shared your screen.
Let's see.
There's a little checkbox usually down in the bottom left corner of the share screen. So you'll have to take it down and share it again.
Hold on a minute. So let me. All right, so see, this is things I don't get. So.
Well, while you're doing that, I think we had another question.
So hold on, share. And then, oh, okay, share sound. I got you now.
Okay, go ahead. Do your thing.
How about sushi?
I just had sushi for lunch yesterday. Indian?
Maybe. How about seafood?
You know I don't like seafood.
How about tacos?
Tacos.
Automatic emergency braking.
So this is clearly an example of being locked in and working from home with COVID, but we both saw this commercial and we like, this is great because this is really what mediation is. You got parties, they're familiar with each other, but they just can't reach what they really want. They threw out some ideas. So those were the parties in the car, and the mediator is that truck. We put that idea in front of you, and then the parties go, oh yeah, tacos. So they came up with the idea they thought on their own, but as mediators, we are guiding them right where we think it will work for them. So we thought that was fun. Hope you enjoyed it.
Any other questions anybody has? Now's the time. And if you want, I mean, I'll stick around if anybody wants or chat or anything. I'll stick around for a while and everybody wants to stay on. But I just appreciate you guys coming on, inviting us to help with this training. And it was great seeing some of you that I haven't seen for a while. And hopefully it's not so long next time I see you.
Yeah, I'll be glad to stay on too. Thank you for taking time to join us today and to listen. I appreciate that. Shout out to folks from DNR. That was my first agency where I was labor relations. This is a big state, isn't it? I mean, it's a big state, and all those parks, you get on there, and it's amazing. And that's a really diverse workforce. So shout out to you guys.
Dot,
Hey,
if you want to
know-
stay on, Dot,
Oh.
you can stay on. Anybody else wants, and we can answer your questions. But I don't want to hold everybody else up past the time too much. So.
No, it was actually scheduled till 1:30, so you can take the
Oh,
question.
okay, great. Well, great. So we're done early. So, okay. So Carolyn, Dot had a question about what a caucus is and isn't, and could you expand on that?
Sure. A caucus is when you are meeting separately, either with just you as an advocate meeting with your client, or with me as a mediator meeting with you and your client, or me meeting with the advocates of both groups. So an example of when I might suggest a caucus. In mediation, it's the mediator's role to, once people are venting, after that's over with, to reframe the statements and calm down, defuse, and separate the problem from the people. So I might use a caucus if I see one person in that mediation that really is a problem. The person is. I might call a caucus to speak to the advocates and say, hey, can you control your manager, or can you control your client, your grievant, because they're putting a barrier up to us moving forward. Sometimes caucuses happen when you want to privately brainstorm solutions that you're not ready to take to the main table yet. And as a mediator, I would listen to that, and I would not take it back to the other party unless you told me I could. Those are the kind of things caucuses are used for. What about you, Joe?
Yeah, it's the same thing. What depends on usually what happens at mediation. It depends on collective bargaining or grievance mediation. Kind of works the same, but I try to set with the parties in joint session, understand what the issue is, understand where both parties' positions are, and then I'll separate the parties, and then I will go back and forth, shuttle diplomacy between, and get as much information as I can. A lot of times the parties themselves will want to caucus and try to regroup sometimes, and they'll say, hey, can we have a caucus? And it's like, sure. We usually say, well, how much time are you going to need? And, things like that. And you say 10 minutes and we go, oh, 10 minutes is up. And I might go and say, hey, are you guys ready? Or give me an update on how much longer you think you're going to be. Because a lot of times what will happen is the parties will hear information or information they had, they get new information, or sometimes they just need a break and go, oh, this isn't going very good. Let's take a quick break. We want to caucus and go in our room and regroup. So it's for all types of different reasons. And sometimes as a mediator, I might say, because parties aren't on the same page and they're talking about different things, and I might say, hey, let's take a quick break. Does the management of the union, I think you guys need to go and caucus and try to get on the same page and come on back and let me know when you're ready. And that's things that mediators have to do. That's part of our job, is to make sure that the parties are on the same page when they want to discuss an issue or a grievance, and make sure they're on the same page when they come in. And if they're not, then I'm going to say, hey, why don't you guys take a break and go in and make sure you're on the same page when you come back.
Any other questions? Do any of you think that you have qualities that might work as a mediator? And what would those qualities be? Come on.
Delphine has her hand up.
Oh, Delphine?
Real quick, who actually can make the request to have this type of a meeting?
Either one of the parties can. I mean, if you're under a contract, it might already be built into the process itself through the dispute resolution process. But private parties can, schedule a mediator on their own, or they can go through, here in Columbus, there's an agency called Community Mediation Services. So yeah, either party can, but the other party has to agree to it because it is voluntary.
So Delphine, what kind of mediation are you talking about, or what kind of meeting are you looking at? Or
Oh, I'm not looking at any, it's just overall who can, is it one of those meetings where, only certain times can a person make that request? Can the individuals themselves, that's having the issue make the request, or does it matter who sets up this type of a meeting? But she did answer one part of it, as long as they agree, anybody can set it up, so.
well, because you're with the state agency, so you would go through, the process through the steps, and I don't know, I think you change it now. Step 2 or 3 would be mediation. So once it gets over to OCB, then they control it, but that would be for grievance mediation. So I mean, if you want to have any thing like workplace mediation or labor management training or labor management facilitation or anything like that, you can give me a call or whatever. But still, like Carolyn said, both parties would have to agree for the mediator to come in for that. Or if one side or the other wants training just themselves, you can say, hey, Joe, can you come in and give us training on management training on this? Then I could come in and give you training on that. The union can also and say, Joe, hey, we're getting ready to go in negotiations. I got a new committee. Most of them haven't been through mediation. Can you give us training on contract negotiations? I would go in and do that. And same with any stewards trainings, things like that. I mean, that's just kind of what our agency does. It kind of separates us a little bit as traditional mediators. As we do everything, with parties as far as training, grievance mediations, contract negotiations, facilitate meetings. We do state, federal, private, all that. And like I said, everything we do is no charge. You just give me a call and say, hey, we want this or that. And the unions agreed to it, and I'll get a contact, from the union side. And together we'll sit down and go, well, what training you need? What do you need? You agree on labor management training because your labor management meetings aren't going good, or you want me to come in and facilitate. And, I do that a lot with state agencies to this day, facilitate labor management trainings, do that, workplace mediations, just through my relationship with the directors and OCSEA.
And I've done.
I'm sorry.
Go ahead, Daphne.
No, go ahead. I was just only going to say, have you guys ran into any issues with the teleworking issues? There's a lot going on there.
I haven't, because I'm not involved with labor right now. But I tell you, as a former active labor person within the state, the whole concept of teleworking just ignites all kinds of issues in my head. And I'm like, oh man, I wonder if they're talking about it. I wonder if they're working them through. But I haven't had that. But what I was going to say is, certainly if you're with the state, you have a mediation process in your contract. But I have worked with other public agencies and even state agencies might, through their HR department, if it's just two employees that want to talk, or if there's a supervisor and an employee that are having difficulties with their relationships, the HR office could work through finding a mediator to come in and talk to you, but that would be outside of the contractual obligations that you have. So that could happen.
Yeah, so, what I try to tell people, and Carolyn also, is, mediators aren't here just for when it gets bad. I mean, we're here to help you in your labor relations or whatever you need. Mediators are here to help you with that. So whatever that resource is that the parties need, that's what mediators are here for. We're here to help you have better labor relations. I can only do things with union people. I do mostly, labor. That's what I do. If there isn't a union involved, I can't do it. I can't, private company that's heard about me or something. Hey, Joe, can you come in? I go, you have a union? They go, no. I said, no, I can't help you. I mean, that is one thing that I can't do, is do any work with anybody unless they have a union. Now, as long as they have a union, I can go in if two supervisors are not getting along and, do a workplace mediation with them, or supervisor and a union employee or two union employees. I can do that. As long as there's union and management involved, I can get involved in all kinds of things. Unlike Carolyn as a mediator, she can mediate whatever she wants to. And that's another difference of what I do and what she does, is I have to have the relationship of management and union, or I can't get involved.
Joe, does the agency charge for those type of services?
No, the only services our agency charges for is, which sounds really funny, is we have contracts with federal agencies to do EEO mediations, and there's a charge for that. But outside of federal agencies using us for EEO mediations, any contract negotiations, grievance mediation, trainings, anything like that is no charge. We get paid by your tax dollars. And so that's why a lot of school districts and things like we do a ton of mediation with school districts and cities and counties and the private sector. But even then, the private sector's mentality of nothing wrong with it, with Teamsters, steel workers, is they really only use this when they really, 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 really have to, because they look at it as, I'm an elected, and if it might make me look weak if I bring a mediator in and they say, oh, well, he can't do his job. He had to bring a mediator in to settle this contract. And so it's kind of touchy with them. And we do get involved a lot with, there's certain ones that use us a lot. And then there's certain private sector unions that I have great relationships with and go to lunch with them before COVID hit. And they would call me and talk about cases, and we might get you involved in this, Joe. We're having trouble here. I just want to put you on the radar. And okay, and never hear from them. I'll call them a couple months. Oh no, we settled that and it went good. And especially in the private sector, sometimes just saying you're going to bring a mediator in, it's like, oh my God, don't bring the mediator in. We don't want the federal government in our business, So so that time, they use us a lot for that too. Is we're going to bring a federal mediator in. The private sector goes, they go crazy. The public sector, it's no big deal, because everything's open in the public sector. the books are open, everything, but information flows freely. And the private sector is, no, you're not looking at our books. No, I'm not telling you this. And the union knows they can't get any of that information unless they cry that poverty and I can't pay. Then it's like, you say those magic words and it's like, oh, great, I can look at your books now. So you never hear a private company ever say, we can't afford to pay you. And you're never going to hear that because it just keeps that out. But I do, because of my relationship with them, you know, I've only been to back in the Columbus field office for, it was less than a year when COVID hit. So, you know, everything was going great. And, you know, my relationships with a lot of you that are in here that I still do work with, and I see it functions and have good relationships and use me a lot. It's you know, it's a different world between public and private sector. But, you know, through those relationships, though, I keep getting more work, and I keep getting more work, and just besides negotiations and some more trust, and for them to understand using a mediator is just another tool in the toolbox to help you get a contract done and resolved. That's what Carolyn and I are. We're a tool in the toolbox for the parties to use to try to help you resolve your issues and get to a contract, or get you to a grievance mediation, try to get a settlement that the parties never thought about, that the parties would never say across the table to the other side, but they could say it to us. You know, we hear all the time, well, Joe, you know, we could really offer this, but we're not going to be the ones to offer it. But maybe if you offered it, you know, in a roundabout way, you know, we go what we call mediator supposals. And it's like, well, suppose I can get the party to do this. Will you do this? And if I can get them to do this, will you give up this? And, you know, and because they don't want to look weak on the other side and think they gave something up that they shouldn't have given, but sometimes they say, I got stuff to give. They're just not asking for it, Joe. So tell them, maybe don't look here, but maybe if you bring up that, hey, how about doing something here? Oh, I never thought about that. Well, yeah, if they can do that, maybe we, you know, and those are the private conversations and the confidentiality that we use, you know, as part of the tools that we use of trying to get things done. And a lot of times, you know, when we're in and I'm with the parties and one party leaves the room and I'm sitting there and I'm on my phone trying to do some work. I mean, I pick up things that I hear, you know, that they might not tell me, but I'm like, oh, you know, I'm hearing this, or I'm hearing this as an issue, and that's not really on the table. And this, so sometimes I pick up more information when I'm just sitting there waiting for the parties to get together, and through their conversations that I just use on my own, not, you know, not that I would say to them later on, hey, I heard you guys talking and I see that this might be a bigger issue that it's not even here. You want me to look at something like that and, you know, throw that in the ring and try to get rid of this, because that might get you some movement. And so there's all types of stuff that we do. And that's why we always ask a lot of questions. And that's why I talk a lot here, because that's part of what I do.
Well, Trejo had another question, Joe.
Who's that?
Trejo.
Okay, go ahead.
I think after much consideration, and since Carolyn asked, and she's from DNR, that I would, I consider being a mediator after I retire.
there you go.
There you go.
You don't have to wait for, you don't have to wait to retire, but you know,
Yeah.
I didn't wait to retire, but
Oh, okay.
Well,
I work for the state, so can I do that?
Sure. I mean, there are certainly some PERS rules about, you know, working again or getting back into the workforce. But if you're starting something on your own, I think being an advocate is the best way to learn, like just learn as you go, and certainly supplement that with other more formal trainings. But yeah, that's what I did. You know, I I started out with the state when I was 17 years old. And so by the time
Wow.
I, like I said, way back in '07, and but I think I'm probably one of the last generations that could work 30 years or so and then retire. But that's what I did. And so I'm still working. It's like I'm too dumb to stop. But it's different. But I enjoy this work. I found a niche that I really enjoy. And there's a lot to alternative dispute resolution, and mediation is just one component of it. So yeah, if that's what you're thinking of, why not?
Carolyn, let me ask you, what is the benefit of having subject matter knowledge? Because both you and Joe come from both labor experiences as well as management experiences. So coming to the table, you have a perspective from both sides and managing the conflict.
Yeah. And I think that's where a lot of my relationship building advice comes from, because it's you're not living in a bubble when you're at that table. You have to go back, you have to live with your contract, you have to live with your people. So you really, and having, like Joe certainly has, having a perspective from both sides really makes a difference. I would say from my perspective, there's been so much change over the years. But I think anybody that is in public sector that has a contract that started out with collective bargaining back in 1986, you have some mature contracts that you should be very proud of. There's very little that needs to really be done in those contracts. And you're always innovative. You're always a step ahead of other contracts from smaller entities. So I think that that's really a good base to come from, is take pride in knowing what the history of your contract, that language, how it's been used. And it certainly helps me coming to the table, knowing that history.
Absolutely. And I use that, as part of my mediation is, what we talked about, it's all relationships. And I'll use on the union side is, hey, I've sat where you've sat. I understand where you're coming from, but you have to look. I'm going to be devil's advocate because I sat on their side. I'm going to tell you, here's what they're going to say. Here's what they're going to do. And the same with the other side. When I'm with the other side, I say, hey, I've sat on your side on the management side. I'm going to play the devil's advocate on the union side. Here's what they're going to say. Here's what they're going to do. Here's what they're going to use. Here, just be prepared, to answer these questions and be prepared for this argument. I use it on both sides, and I get that relationship from both sides because, the union knows I've been on the union side, and management knows I've been on management side. And believe me, as a mediator, when I walk in the room a lot of times and I'll do my introductions and go through, I don't know how many times I've heard, don't worry about it. We've already looked you up. We know all about you anyway, so don't worry about it. And that is true. They go and they look at the mediator. They look at your background, where you come from. If you've just been on management side, then they're going to take the approach sometimes when you're on private caucus and say, well, you've only sat on the management side, so you don't know how it is to be on our side. And vice versa. If you've only been on the union side, management will look at you and say, well, yeah, you've been a union guy for so long, you don't know what it's like to be on the management side. And I can use that and say, yeah, I have. I've been on both sides. I know where you're coming from. I know what you're arguing. And most of the time, when I get in there, or, we've been doing this a long time, when I see something, I can probably say, yeah, I know how this is going to turn out, and it usually turns out kind of close to what we've done, or we've been in grievance mediations and they didn't take a deal and they went to arbitration. The side that lost could have had a better deal, and and I don't do it, to rub their nose in it, but I'll call and say, hey, whatever happened in that arbitration? Oh man, you had a better deal in mediation, didn't you? I said, but it's the relationship I have with them that they just laugh and go, yeah, Joe, I know, but and sometimes they go, Joe, I know, but I have to do it for this reason, or I have to do it for that reason. That the director said no, he wouldn't take the settlement, or the grievance said no, they wouldn't take the settlement, or I just found out, I got doing a mediation and it was the best deal they've got in 20 years and they just turned it down. And I'm thinking, what? I mean, and it's like, yeah, we're going to need you again. And I'm like, well, I don't know what you expect, because that's the best deal you've ever gotten. And, and it's like, all right, we'll get back together. But, I don't know why it was turned down, if it was for money or just for something else. And so, like I said, I don't know until I get back in there. But yeah, we have our opinions when we leave, and we can't show that because we're neutral. So sometimes I walk out and go, ooh, man, that side got screwed, one side or the other. But that's in my mind, because or man, I can't believe they settled for that, and on whichever side it is. But it's not mine. Just like the advocate, sometimes I got to look and go, it's not my contract. It's their contract. So I'm not in there advocating for one side or the other. If they get a deal and they're happy with it and that's what it is, they came to it, I'm good with it when I leave.
Well, that's what Mick says too. They got what they need.
Yeah, they got what they need,
Treva has another question.
Hey, so you mentioned about, let me ask you this. How often do you, as mediator, follow cases to the end? I mean, I imagine you would have lots on your plate, but well, because then obviously you guys are interested in this work, and from just being here and presenting, but do you typically follow all cases or just a few cases to an arbitrator, or in between mediation and arbitration, do you follow whether they get settled or not, or if they perhaps took your advice, or how often?
And let me reframe that, Joe, too, because I want to add, how do you measure your success as a mediator?
Okay, so for me, measuring success isn't always about did you get a deal or not, because sometimes the deal was there and they just didn't take it. So it's hard for me to measure success. I always feel good when I get a deal. It's like, oh, I come, it's great when I walk out there and they got a deal and that's succeeding. But sometimes, I walk out and I go, I can't believe they didn't take the deal, or I can't believe they didn't settle. And then, and then I do follow the case. Usually the parties will come back and tell me about it, because usually I work with the parties a lot. And so I'll know and I'll follow up. And Maida and I was just talking about this today, because she had an arbitration scheduled. They called me. I didn't know who the arbitrator was. We mediated. We got a settlement. When we were done, I said, oh, okay, so who was the arbitrator that was scheduled to hear this? And they said Maida was. And I was like, oh, she's my friend. Next time I see her, she's going to give me a hard time. And she gave me a hard time today, and I got to take her to lunch now, because I cut her out of a big chunk of money. So now I got to take, but I try to follow cases only because I work with the same people a lot. So, and it's curious for me, if there was a deal to be had, and then what happened down the road, that a lot of times in between, like you said, mediation and arbitration, they'll settle. Sometimes they don't settle that day because they need more conversation. They want to make sure, and they'll settle. But when they go to arbitration, usually I will follow up, or I'll hear about the arbitration down the road, and I'll say, well, what was the outcome? And they would tell me, and probably 80% of the time, 90, it's about, either what they could have got in mediation or had in mediation. But sometimes I'll go, what? Because of my background, I just go, what? They did what? The arbitrator did what? And so, and then I'll go, who is the arbitrator? No, I don't know them, So yeah, like we talked about earlier, arbitration, like Carolyn said, you can have the best case in the world and lose, and you could have the worst case and win. Arbitration is arbitrary. You don't know what's going to happen. They're just regular people like us. depending on a lot of times is how advocates present the case, how good your witnesses are. If you could have a great case and have bad witnesses and lose on that, but the facts are there, but your witnesses are terrible. And if I'm in mediation and they go and I see some of those witnesses on one side or the other, I go, you guys are going to have a hard case because your witnesses are bad. And so, a lot of times that'll get the settlement, but, to answer your question, I always try to follow up sometime, maybe, not right when it happens, but, if I work with them down the road, I'll go, hey, whatever happened with that? Or if it pops in my mind and I thought that was a good settlement, they turned it down, I want to see what happened. And I'll go, hey, whatever happened? They'll tell me. And okay, yeah, I know we could have had it done and we had a better deal. Don't tell me, Joe. I know, because I have those relationships with them.
What has been your experience, Carolyn? I'll give you the last word because we're at 1:30.
Oh, okay. Well, presently, the bulk of my work is with special education through the Office for Exceptional Children, the Ohio Department of Education. So their complaint process is a little bit different. They have complaints that are issued in a timely manner, like within 60 days. And so sometimes I'll get called in to mediate those before a finding and recommendation is done. And those results are posted online, so I can see cases that didn't resolve with me, what happened. And then I can just sit here with my nerdy self and say, oh, they should have listened to me. And then they also have a due process where they go into full due process, which is a full where all the evidence is submitted and witnesses are sworn in, and there is a mediation step, and it's the same thing. Those things will get posted. So I do follow those cases, and I also follow some labor cases that are still going on because I have some colleagues that are still doing labor arbitration, and because they know that I've been in the field for so long, they'll run fact patterns by me before they write their decisions and say, well, what would you say about this? And I would say things like, well, I'd never hire you again as an arbitrator if you ruled that way on me, that kind of thing. So I do keep my finger on stuff as they go along and as it goes. So that's how I would say, yeah, I do track it. I don't just let them go. One other thing that they do, sometimes the cases I settle now, they will have in the agreement additional meetings that they want to have as part of their overall settlement. And they'll retain me as the facilitator for those meetings. So I do live those agreements through.
Well, thank you both for the presentation today. I think we learned a lot about mediation and negotiations. I see a lot of hand clapping coming your way.
Thanks.
Thank you.
Appreciate it.
Before ending the session, I would like to convey a special thanks to Bernadette and Emily for everything they do for Colera, from hosting these conferences, managing our website, and providing us tech support, which we badly need. You make our organization look good, and I want to publicly acknowledge this with this group. I also want to thank Christina Hasselberger, who is our vice president, and Don Collins, who's our secretary treasurer. Don is not here. Christina is. Christina, do you have any remarks?
No, just you're very welcome and always glad to help.
Okay. So although this is our last day of the Academy, I hope to see everybody back on the third Tuesday of the month for our speaker series. And we will be testing a new pilot program for our virtual members, Colera Table Talks, Conversation and Copy. And we'll be doing a test program in April for that one. I hope you all join us. You'll all be receiving notices. So have a good weekend, everybody. And hopefully I'll see you, I think it's March. I don't know what that date is in March. March 15th. And our program is involving diversity. I think the host is going to be OE8 on that one. But,
okay.
Yeah. See you next month.
Bye. Thanks.
Bye-bye.
Thanks, everybody.